Hello, I'm Matt Galloway, and this is the Current Podcast. This week, the Supreme Court of Canada is hearing a landmark challenge to Quebec's Bill 21. That's the law that bans certain public employees from wearing visible religious symbols. Amrit Kaur graduated the day that Bill 21 was adopted, but had to give up her dream of teaching in Quebec because she is Sikh and wears a turban.
It's different to move on the premise of a good job opportunity or you want to travel the world. But to move because of religious persecution, that just makes you feel like a second-class citizen.
On the other side of the argument are the Quebec government and advocates for secularism, or laïcité, people like Mandana Javan.
This is a very bad sign that we start to convert kids in daycares, in schools, because I lived that in Iran and I know how does it work.
This case is part of a long-standing debate over secularism, nationalism, and multiculturalism in Quebec. To help us understand how we got here, I'm joined by Daniel Beland. He's a professor of political science and director of the McGill Institute for the Study of Canada. Daniel, good morning.
Good morning.
The law that is being challenged in court this week is called an Act Representing the Laïcité of the State. Can you explain what that concept means in Quebec?
Yes, so laïcité or secularism, and I think it's important to understand that they actually use in English, in the English translation, they use laïcité, which is a rather weird, not very common used term in English, rather than secularism, because I think the government wanted to emphasize the specificity of Quebec's approach to secularism compared to what is done elsewhere in the country. I think there is a direct influence from France here, and France is the kind of the birthplace of modern laïcité or secularism, and it goes back to the French Revolution, but especially to the Third Republic in the late 19th, early 20th century. It was the aftermath of the Dreyfus affair, which involved anti-Semitism, of course, and modern laïcity in France was really about a strict separation between the state and the church. And the church here was the Catholic Church. The emphasis was really on Catholicism, and to prevent the Catholic Church from challenging in France, the Republic, and also threatening religious minorities, including Jewish people, but also Protestants. Now, if we look at Quebec, the Quiet Revolution in the 1960s focused a lot on removing the church from major institutions like the healthcare system and the education system. And so the emphasis was again on the Catholic Church. That's no longer the case, of course, today in France or in Quebec. And the focus is much more on religious minorities and that are tied to immigration.
Help us understand that, because when it comes to the current Quebec context, you have the issue of wearing religious symbols like a turban or a hijab, which has become an explosive political topic in that province for the last couple of decades. Why is that the case?
Well, there is a process of secularization that began during the Quiet Revolution in terms of the institutions. So, of course, you had the creation of the Department of Education in Quebec was only created in 1964. In Ontario, for example, it was created in 1876. So there was no Department of Education up to that point in Quebec because the church was so dominant, at least on the Francophone side of things. So gradually, of course, Quebec created a modern public education system, and gradually religion was removed from it. But it's only gradual. It's only in 1997, I think, that we created language-based rather than religion-based school boards. So until that time, it was Catholics versus Protestants, and after that, it became Anglophones versus Francophones. But I think what has happened since the Bouchard-Taylor Commission in the mid-late 2000 is the emphasis on first what they call reasonable accommodations, which were really religious accommodations for minorities like Jewish people and Muslims, and then that became a big electoral issue in Quebec, strongly supported by, at the time, the ADQ, Action Démocratique du Québec, with Mario Dumont, and it was very successful for them electorally. So then the Parti québécois embraced that logic, and that led to the proposal for so-called Quebec Charter of Values, or Charter of Quebec Values, and then the PQ lost in 2014. The Liberals tried to address this issue of reasonable accommodations and secularism, and then, of course, the CAQ in 2019 enacted Bill 21. But Bill 21 goes farther than what the Bouchard-Taylor Commission had recommended, and had recommended a decade earlier. The emphasis is really on, as you mentioned earlier, on religious symbols. That was not the emphasis of secularism, laïcité in Quebec during the 1960s, for example. And this shift, I think the focus on what people wear and implicitly the focus on religious minorities is a trend that became in France in the late 1980s with the l'affaire du foulard, the hijab affair. So there is an implicit connection, and explicit in some cases, with Islam, and especially with what women wear. So the hijab.
The question that people might be asking from outside of the province is there has been a lot of demographic change elsewhere in the country. There doesn't seem to be the same level of concern about religious symbols elsewhere as compared to in Quebec. And in Quebec, you have this challenge to Bill 21, but there are laws that go even further. There's restrictions on public prayer. There's bans on religious symbols to daycare workers, for example. What is this really about, do you think?
There are, I think, a number of factors. I think one key factor is, and it's often mentioned, that it's an historical factor, if you want, what is specific about Quebec's history. There was a very strong role of the Catholic Church up to the 1960s, and a lot of, especially older Francophones, are resentful of, I would say, the idea of a visible central role of religion in society, that's tied to their own experience of what they heard about, the Duplessis era, what happened before the Quiet Revolution. There's also, I think, anxieties about Quebec identity. There is the focus, of course, typically on language, but that extends beyond that. The idea that Quebec is a distinct society is different, and that and now I think the CAQ has emphasized this idea, and I think the PQ is certainly on side with this, that laïcité, the way they define it, is part of Quebec identities. And there's also, I think, the last point is the influence of France, that people elsewhere in Canada don't always think about that much. But, here in Quebec, if you watch Francophone televisions or you read Francophone newspapers, there is quite a few references to laïcité and the debates that are taking place in France. And that is something that is related, I think, to language. And also, I would say even, it's a bit of a stretch, but post-colonial legacies, in the sense that, Quebec used to be a French colony. And I think Quebecers know more about what's going on in France than people elsewhere in Canada. And in France, they have been talking a lot about laïcité, about secularism, since the late 1980s.
Let me just ask you finally, when Bill 21 was introduced, everybody assumed, or most people I think assumed, that it would be challenged, it would go to the Supreme Court. You have an election in Quebec that's coming up in the fall, and the Parti québécois is leading in many, if not all, of the polls leading up to that election. What do you think the political consequences would be in Quebec if Bill 21 were to be overturned at the Supreme Court?
Oh, if it would be overturned, especially during or just before an electoral campaign, I think this would be like an earthquake, right? Or even maybe an atomic bomb. I don't know what metaphor to use. Let's stick to earthquake to not be, too dramatic, but it's still quite dramatic. Yeah. I think that it's clear that if it will be overturned, because the issue here is not just Bill 21 and laïcité, it's also the use of the notwithstanding clause more generally. And people, there is strong support for the use of the notwithstanding clause in Quebec. And also support for Bill 21 among Francophones, at least, is strong, especially among older Francophones. And so, obviously, if there will be say that the Supreme Court will strike down Bill 21, there will be a lot of outcry. There will be, especially will benefit, I think, the CQ and the Parti Québécois, because the Parti Québécois, which is a sovereignist party, has even a harder line than the CQ, adopted a harder line than the CQ over secularism, laïcité, and also they, of course, both parties defend the autonomy of Quebec, and that will, and so the notwithstanding clause is perceived as Quebec as a tool of provincial autonomy. And also, don't forget that Quebec never signed the 1981 agreement that led to patriation in 1982 and to the adoption of the Charter of Rights and Freedoms. And the PQ, when they were in power from 82 to 85, they used the notwithstanding clause in a blanket manner. They basically snapped they adopted the notwithstanding clause for all the new bills and retrospectively to all the bills in Quebec. So, and of course, it's been used a number of times, quite a few times since the mid-1980s. And so I think that there is strong support in Quebec for both Bill 21, although it's controversial, you're absolutely right, but among Francophones, and even if you take the population in general, support when it was enacted was about 2/3 of Quebecers supporting it, and support for the use of the notwithstanding clause that people strongly associate with the autonomy of the province.
Those are high stakes. Daniel, we will leave it there, and we're going to speak more just about the notwithstanding clause more broadly, but I really appreciate you being here. Thank you very much.
You're most welcome. Take care.
Daniel Beland is a professor of political science, director of the McGill Institute for the Study of Canada.
The decision that the Supreme Court justices will render on Bill 21 will in large part determine whether Canada continues to be a liberal democracy that is the envy of the world or something less, something that we cannot afford to accept.
If the Supreme Court agrees with them, that means it's a constitutional revolution. It would give much more power to the judicial branch and more precisely to the Supreme Court and less power to the legislature, especially provincial legislature, especially the National Assembly of Quebec.
Those were Stephen Brown of the National Council of Canadian Muslims and Guillaume Rousseau, the lawyer for the Mouvement Laïque de Québec. They are on opposing sides of this issue, but both see the stakes here as absolutely crucial, as you heard, to the future of democracy in Canada. This case before the Supreme Court has attracted a huge amount of interest across the country. A record number of respondents and interveners are weighing in. So to help us understand what is at stake here, we're joined by Eric Adams, constitutional law professor at the University of Alberta. Eric, good morning to you.
Yeah, thanks. Great to be here.
What is this case really about, do you think?
Well, one of the signals right away that this is a momentous moment at the Supreme Court is the number of days that they've devoted to this, almost an entire week, 4 days of hearing. That's very unusual, almost unprecedented. And as you said off the top, the number of parties, interveners, and governments that have taken a direct position here. You know, Professor Beland, who spoke to you a moment ago, was talking about this case as a story very much of Quebec, but the fact that the notwithstanding clause was used in this legislation also makes it a story of Canada and of our Constitution. And so a number of governments, a number of citizens, and a number of, I can tell you, the legal community are all watching this very closely.
Some of those interveners are arguing that the court should establish limits on the use of the notwithstanding clause. What would that look like if that were to happen, do you think?
I think it's important first to just note that the notwithstanding clause has, of course, been used relatively frequently in Quebec, but it received an uptick in uses starting in about 2017, and we saw uses by Saskatchewan, Ontario, Alberta, and so that has placed it back into both the political conversation and also the legal conversation. And it was only one previous Supreme Court of Canada that really dealt with the notwithstanding clause head on in 1988. And so this is really the first time in almost 40 years that the Supreme Court has had the notwithstanding clause, what it means and how it operates within our Constitution, squarely back before it. And so for that reason alone, it's a monumental moment. And a number of people are making the argument both that the Supreme Court should change the approach that it adopted in 1988, which is a relatively hands-off approach to the notwithstanding clause, and try and provide some scope or limit for its use beyond perhaps what is even written in the text. Other people, and certainly a number of governments, provincial governments that have used the clause, are saying absolutely the opposite, that this is a linchpin of the charter bargain and that it preserves parliamentary sovereignty for governments in provinces and federally to make any law and to make that decision without the interference of courts of when the notwithstanding clause protects that law.
What did you make of the fact that a sitting politician in the Attorney General of Ontario, as well as the Deputy Attorney General of Alberta, were in the court themselves yesterday making arguments saying, keep your hands off of the notwithstanding clause?
We certainly don't see that very often, and I think it was a strategic move on the part of both Ontario and Alberta to signal to the court. I mean, they appeared by Zoom, which is the court's practice on how interveners who are not direct parties appear in the case. But I think they wanted to send a signal to the court, and I think the court is certainly of the view that this is an important case. They probably don't need reminding, but just how important this matter is to the governments that have been using the clause, because what they see as a potential here is that the Supreme Court is going to possibly, if they accept some of the arguments that are before them, either limit the ability of provinces to use the clause in some ways by adding some conditions, or to, once a province invokes the notwithstanding clause, one of the arguments is that the court still has the capacity to rule on whether or not a charter infringement exists. They can't strike that law down, but perhaps they might still be able to, in a judicial decision, either declare or describe the ways in which this piece of legislation would affect freedom of religion, freedom of equality rights. They can't do anything about it, but they can state in law that this infringement occurs. A number of parties are asking that the court adopt that practice, and Ontario, Quebec, Saskatchewan are saying very forcefully that no, the notwithstanding clause should not allow that practice.
Just in the last couple of minutes that we have, people will say that this could lead to a constitutional crisis. There are very deep legal ramifications for this as well. But in very, I guess, concrete terms, how would this decision by the court affect Canadians, particularly outside of Quebec? We've talked a little bit about inside Quebec, but outside of Quebec, how could this decision affect people across the country?
Well, since 1982, we've had two realities coexist. One is that you've got a Charter of Rights and Freedoms that guarantees your rights to freedom of religion, to equality, to life, liberty, and security of the person. And it means that government laws cannot deprive you of those rights if the interference in those rights is unreasonable. And that was a signal change in Canadian constitutional law when that rights moment occurred. But you just have to read 32 sections of the Charter later, you get to 33, and that section says that actually governments, Parliament, and provincial legislatures can protect their laws from certain of the charter rights that would otherwise be there to strike those laws down for a period of 5 years, and governments can renew that 5-year shield, if you want to use that metaphor. And so for Canadians, what is the meaning of the charter? What are those meanings of the rights that are guaranteed there? And what is the capacity of governments to potentially use the notwithstanding clause shield to continue to have an impact on the way that people experience their rights and freedoms in this country? And what powers do governments have to define their own sense of where those rights and their limits should be? All of that is squarely before the court.
That's as sweeping as you could imagine in some ways.
That's the reason that this course has been identified for years as being one to watch, and we'll have to see what the court does with this monumental task that it has in front of it.
We will watch closely and perhaps speak again. In the meantime, Eric, thank you for this. Really helpful.
Yeah, pleased to be here.
Eric Adams is a constitutional law professor at the University of Alberta. He was in Edmonton. You've been listening to the Current podcast. My name is Matt Galloway. Thanks for listening. I'll talk to you soon.